Good afternoon and welcome to another session of Lunch and Learn. To all those that are joining us from all the different platforms, most very welcome to all of you. Those that join us on Facebook, welcome. Those that join us from our website that received the link to join, welcome to those as well. Today we will be addressing how to submit your completed maintenance application to the maintenance court in order to fast track your maintenance application. Now, we have had quite a number of inquiries regarding certain aspects of our previous Lunch and Learn webinars that we will be revisiting as we go along. So if you do have a question, please just pop us an email on info@lunchandlearn.org.za, and we will address those type of issues in future or in further webinars. We'll include that as part of the structure then. So what we will be discussing today, obviously, like I said, it is all the nitty-gritty when it comes to submission of the documents to court. So everything that you need to take with you to court in order to fast-track your maintenance application form. We will be discussing what documents, what do you need to take, and what order you need to take them. And how should they be submitted? To whom should they be given? What you should do in order to make sure that your maintenance application receives the attention that it needs. We will be offering practical tips and common problems when it comes to the submission of the application form. And then most importantly, and that came out from previous webinars, is the issue of the submittance or submitting of documents or the income and expenditure. We found that so many people had so many problems with regards to that, and we will be addressing that issue. I'll do a portion on how you could use an Excel spreadsheet in order to note all the expenses and how to work out the formulas. And that can form part of your maintenance application form that you could submit to court. But that will work through as we progress through this lunchtime webinar. So grab your cup of coffee and let's do some learning. So let's just jump right into it. Once again, welcome to all those people that registered for the webinar. These webinars are presented free of charge, and you can register on www.lunchandlearn.org.za. You register there, and then a day or so before the time you get a link, a direct streaming link. If you do have difficulties accessing the link, the video the webinar will be made available, or will be available afterwards as well. On that link, you would also then receive obviously a link to the website, and on that website you would have access to some pre-reading material. If there's any pre-reading material that we've compiled for you, then you can read through that. That usually contains some history, some background information about the topics that we will be discussing. Obviously, there will be the link of the live webinar, and then most importantly, the handout and resource tab. Now, in that tab, we dump all the case law that we're referring to, all the templates that we're referring to. If we do have affidavits, we put that in there as well. And those are all available that you could download and then use for your own purposes. So if you have registered and you are watching through the website, or you've received the link, then that would be available to you. Those that just joined us on Facebook, obviously they have not registered. I would urge you to register for future webinars in order to access those valuable resources that is available on the resource and handout tab. Right, so let's just jump right into it, and let's just go. What do you need? What is needed for you, and what do you need to take to court? Now, this has been addressed in a previous webinar, but we can run through that because that is important. The most important of everything is that you have to have your groundwork ready, have your application ready, have your documents in the correct order, have all your documents needed, have that ready in order to avoid that your case will be postponed and you have to go back to court each and every time in order to just give new documents and submit more documents, more proof and stuff. So my advice would be is get everything ready. Spend some time beforehand. Don't just venture off to the magistrate court or the maintenance court and then submit the documents. I would urge you to rather take some time and gather all the information, make it as complete as possible, because that would be to your benefit at the end of the day, so that your case will not be remanded and your case will be attended to expeditiously. So what would you need? Obviously, your ID document or a copy thereof. If you do not have an ID document, please remember, in terms of the DOJ Code 26, they cannot turn you away because you do not have an ID. They have to assist you to obtain an ID. But if you do have an ID, or you have a copy of your driver's license or a copy of your passport, take that with you as well. Very important is the certified copies of the children's birth certificates. So if you do not have that beforehand, please pop into Home Affairs, get all those copies, because that would definitely, the courts will definitely ask for those copies in order to process your application form. Most courts would ask for at least 3 months banking statements. If you do have a bank account, then ask the bank that they give you the original copies thereof. In later proceedings, if the matter escalates and it goes to court, then the maintenance officer might ask you for additional banking statements that you have to submit in order to prove your expenses and your income and so forth. So bear that in mind, and always have if you need to go to court, always have the latest copy of your banking statements ready, because that would expedite the proceedings, and there would be no reason for it to be remanded again. If you do have employment, or if you are employed, have a copy of your latest payslip, or at least 3 payslips. If you do the application, have at least 3 months payslips available. Ask your employer to give you the payslips if you do not get that already, or if you do work, like for example a domestic worker or so, just ask for the person that you work at for an affidavit stating what is your income, because the courts will always also look at that. Proof of your address is also needed. That could be a utility bill, or it could just be an affidavit to say, okay, right, you know what, I live at this house, which is also accepted at court. Very important, the names and the details of the person that you claim maintenance from. That is usually the father. If you're the mother as the complainant, you need the details of the father, or you need some form of details or identifiable detail that the court could proceed with this matter. If you do not know where the father is, and you don't have an idea, and you do not know his ID number, and you do not even know what his proper names or his full names are, chances are very slim that your matter will be attended to, because the courts will come to your assistance to a certain degree in order to assist, in order to track and to trace or to investigate, to try and get the whereabouts of the respondent or the father. But if you do not have any information about the father, then chances are very slim that you would proceed, or that you would actually go any further than the application phase. The courts need those details in order to get. Why do the courts need that? The court needs those details in order to get the father or the respondent to court in order to investigate the matter. So if you don't have any details, chances are very slim that the court would have those details at hand. So at least have some of the details ready. That means, it does not mean that you have to have everything ready, but if you have his ID number, that would most definitely suffice, or even his full names and his date of birth. That would also assist, because then the maintenance officer could instruct the maintenance investigator to assist in tracing or to locate his whereabouts. Obviously, if you are divorced, then a copy of divorce decree is also needed. And then very important is a list of your income and your expenditure. And we've addressed that in previous webinars, but we'll go into that some more details. Now, yes, and I think this is quite important. It is not necessary, because the J101 form includes what you need to take to court. It includes a form, because it's a 6-page document, where you can jot down your income and your expenses, and then make the necessary split between the child and the parent or the complainant. That is so. It is available on the form, and most people just fill in that form. I look very skeptical towards that form because that form is not always indicative of what is the true expenses. And there's very little space. And it also does not mean that if there is a portion, say, for example, gifts or religious contributions, that you have to fill that in. People think that they have to complete each and every item on that list, and that is not so. So that is not indicative of your expenses. It might not be indicative of your expenses. Our advice, and we've done that, and I do that in my practice in each and every case, where I request the mother to complete a spreadsheet with the expenses. Now, why do I do that? Isn't that duplication? Yes, in some instances it could be duplication as well. But with an Excel spreadsheet, you can work with formulas and you can work it out, and you can, I wouldn't say manipulate that, but I'll explain in a moment what I mean by that. But that is easy to change. If you need to change the figures, and if you omitted something, just to add that, then to submit an additional Excel spreadsheet would be very, very, very advantageous to your furtherance of your application form. I also look once, if I need to go to court and I look in the application form and I see the form is filled in and it's 500 Rand for this, 500 Rand for lodging, 300 Rand or 800 Rand or 2,000 Rand on the dot for food, and it's 500 Rand for fuel, and it's 200 Rand on the dot, then I take some caution with regards to that, because then it tells me that, you know what, there was not much in the thought process of establishing those figures, and it might have been a thumbsuck at the end of the day to get to those figures, and then that would open the door for me as a legal practitioner for severe and vigorous cross-examination, because you know what, no person in South Africa would spend 2,000 Rand on the dot, not 1 cent more, not 1 cent less, for example, on food. The chances are basically none to zero to non-existent. So if you usually have a form like that, then it shows me that not much thought has gone into the compilation of that form. And that is quite troublesome, because this forms, the J101 form forms the basis, the ground root, the basis, the foundation of your affidavit. And if that is not done correctly, then your case might not succeed in the way that you expect it to be. And that then your expectation, what you want out of this, might not be met. So if we look at the spreadsheet, and why do I say the spreadsheet? If I can just bring up the spreadsheet, I can make that a little bit bigger, then I can check that out. What I mean by the spreadsheet and why I like the spreadsheet. Now, the spreadsheet is a simple Excel spreadsheet, and you can see that everything that is on the J101 form has basically just been copied. But I make a note at the top to say, but you know what, I've taken 3 months expenses, the average over 3 months, for example, from December to January, to calculate these. This is based on 2 children, that is, well, obviously the mother, 2 children, ages 6 years and 17 years old. This is just by way of example, so that you can see what I mean by how we can manipulate or to change the figures to make it more clear and more reasonable and more fair. So let's just use, for example, I include, obviously, you would see that in the form as well, complainant, child 1, child 2, and then a total. I include in the spreadsheet, I include 2 columns. I include the column called calculation based on, and then the reasons for that. Why do I do that? It is in order to show the court that there's gone some thinking into compilation of this. This is not just something that you suck out of your thumb in order to complete the form and just to fill in the little blocks. So if one looks at, for example, we look at the expense of lodging. Now, I've marked 3 scenarios which could be used. And this is why I like using a spreadsheet, because you can delete something or you can add something, and you can manipulate what it looks like in order to make it more to your advantage at the end of the day. Let me explain what I mean by that. Say, for instance, we have the total amount of lodging for 7,500 Rand. Remember now, that's for a mom and then 2 children ages 6 and 17. So now we all know, and we've learned that from the previous webinar, that South Africa has a discretionary system. With other words, in terms of Section 15.3, the court would apportion the expenses towards the children in a certain manner. It is a discretionary system, so we do not have a fixed formula. There is no fixed formula to be used. Although we use the principle used in the case of akut versus akut, that was also amplified, and in the case of Santam versus Fourie. But that is logistics. Basically, what it says in the akut principle is, and that is used quite often specifically in the courts in the Western Cape, where we allocate 2 shares for each adult and then 1 share for each child in order to work out how do you split the expenses between the child and the complainant or the mother. But let me show practically what is meant by that. So if we use the akut principle, let's go to this one here. If we use the akut principle marked here that I've just highlighted, the akut principle says that we allocate 2 shares for an adult and 1 share for a child. So we've got 7,500 Rand as an expense, as a lodge expense or lodging expense. That could be rent or it could be a bond payment. So how the akut principle allocates that is we count the amount of people in the house. There's 3 people in the house. It's mom and the 2 children. And then we allocate the shares. 2 shares for the mom, and then 1 share per minor child. So what we do there is we divide the whole amount by 4. So that would mean that the mother pays 3,750 Rand, and then each child's contribution is 1,800 Rand. That is according to the akut principle. But let's go further on this, which means that you, as the complainant, would pay the majority share thereof, 3,750 Rand. Now, one would think, is that fair? Remember, I said that we work in terms of Section 15, we work with a discretionary system in South Africa. So let's look at other ways that could also work. And that's why I like using a spreadsheet, because then you can actually see the figures black on white and which would work mostly and which would be fair and reasonable in your instance. Okay, if we share, we go to the top portion. If we share that amount, the amount of lodging, remember now there's mom and then there's the 2 children, 6-year-old and 17-year-old. If we share that equally, and the reasoning for that is we share it equally because the children has their own rooms, they've got full access to the bathroom, they've got full access to the kitchen, and they've got full access to the living room. So if we work that out per square meter or per area, then it could be considered fair that each and every child needs to pay their share, or it should be shared equally. If one do that, it means that you take the 7,500 Rand, the total amount, and you divide it by 3, and each party, the complainant, the child, and both children, each pay 2,500 Rand. Or there's another way that we could do that as well. And I've seen that, and I've worked with that quite a lot, is where the children obviously have their own rooms, but then they only share proportionate in the common areas, such as the bathroom, the kitchen, or the living room. So I've done that simple calculation. I've done that here. Okay, there we see, okay, right, the rent is 7,500 Rand, and then we work out, okay, right, there are 6 rooms in the house. So we divide that per room. So each and every room is allocated an amount of 1,250 Rand. Obviously, mom would pay for her own room or be responsible for her own room. The 6-year-old child, 1,250, that's their portion. And then the 17-year-old as well. That seems fair. That seems reasonable, and that seems fair. Now, we say, okay, right, now we're still left with the living room, the bathroom, and the kitchen. If we use those amounts and we work it out, right, okay, let's say, for example, the living room. Mom should spend most of her time there when she's at home, so she uses it 50%, and the children only uses it 25%. Same goes for the bathroom, same goes for the kitchen. Or not same with the kitchen. The kitchen, we actually allocate to say mom uses the kitchen about 80% of the times, and the children each only 10% in order to get to a figure. If we apportion that in order to get a fair amount, to say, okay, right, mom, like I said, they shared the common areas, then it gets allocated 625 Rand for mom for the living room, because that contributes to 50%. She shares 50% of that, and the children 25% each, which amounts to those. If we look at the kitchen, for example, we said, okay, right, mom spends 80% in the kitchen, then she needs to pay 1,000 Rand towards the area of the kitchen, and the children 125 Rand each. So if you calculate those and if you add those up, it would mean of the total amount of 7,500 Rand, mom needs to pay 3,500 Rand, which equates basically to half, or just a little bit less than that. And then the 6-year-old's 2,000 Rand, and the 17-year-old also 2,000 Rand. So that is one of the models that could be used as well. Now we sit with the three scenarios. We sit with scenario one, where it's been shared equally, one which is shared much more meticulously, a little bit worked out, and that shows that there was some thought given to that. And then we use the acute principle. So let's analyze this and let's unpack this quickly. So it means that if you use the acute principle, which is used in courts, and most magistrates and most legal practitioners favor that, it would mean that the mom needs to pay 3,750 Rand, or contribute that towards the rent, and then the children only those amounts, 1,800. But is that really fair? Because if one looks and one could reason and justify that the children should be, and everybody in the house has equal rights to each and every portion of that house, then a shared portion of equal standing would suffice, and that could be justified in court. So this is how the figures would be influenced. If you simply uses the blanket provision of acute versus acute, then it would mean that mom needs to pay or contribute 3,700 Rand. If she only uses if she uses the fair principle, the discretionary portion of equal share, it means that she would contribute 2,500 Rand. And if she uses the formula working out per area, then she would need to pay 3,500 Rand. This in effect would mean that the amounts that you can claim maintenance would change. So the lesser amount that the mom pays on this side, on the complaint side, the more the maintenance will be. If you can justify that, then that would mean that you could actually, by way of not meticulous calculation, but basic assessment of your situation and justifying that with reasons, could actually get more maintenance than you would have bargained and that you would have gotten by simply using the acute principle. So here's the manipulation part, like I said. So if you work out the spreadsheet and you have those, and you can see, okay, right, these are the three scenarios. Which scenario would benefit me most? Obviously, the first one would benefit you most. And what you simply could do, you could hide that, or you could simply delete those. And then okay, right, that is the portion that you need. That is what you can submit to court, and then you can tell the court that you've used, the calculation that you've used was based on the discretionary formula, or the discretionary provision in terms of section 15, and the reason for that. The reason was that the children has their own rooms, they've got their own, they've got 100% use of the bathroom, the kitchen, the living room, so it should be split equally. Same goes for groceries. I've used the exact same principle, the exact same reasoning. If we use the acute principle, for example, we've got a total amount of 6,000 Rand for groceries. Then if you use the acute principle, there you could see that the mom's contribution would be 3,000 Rand, 1,500 Rand for each child. But if you use a discretionary one, start off with a good one, and then afterwards adapt it to see, does it work for you? Does it not work for you? If we use, for example, mom says, you know what, mom, it's 40%. of the food that is bought because she's an adult. But here comes it in. You know what? The 17-year-old and 6-year-old do not eat the same amount. The 17-year-old would probably eat more than the mother. But let's keep it fair and say, okay, right, you know what? The 17-year-old only eats 40%. And the remainder, 20%, is allocated towards the 6-year-old. So that is an easy calculation to make to say, okay, right, of that 6,000 Rand that is allocated or spent on food per month. Obviously, that amount won't be a fixed amount, 6,000 Rand, because you would need to submit proof to say this is the amount that you used or for per month. But I'm just using 6,000 Rand as a ballpark figure. So if you decide, if you work it out on the basis, mom eats 40%, the 17-year-old eats 40%, and the 6-year-old eats 20%, which seems very reasonable, very fair in terms of the discretion that the court might have, then it would work out, and that's a simple calculation. There you can see it's 40% of the 6,000 Rand amounts to 2,400 Rand. The 6-year-old, which only eats 20%, amounts to 1,200 Rand. And then the child of 17 years old would also eat 2,400 Rand. So that is the discretion, the portion. If you compare that to the acute principle, it shows quite a different story. So if you were to use the acute principle of allocating this, the blanket one, the one share, 2 shares, it would actually mean that you get out less. Same goes, for example, if you simply split it by 5 and you give the total amount, that is also one of the formulas that could be used. But here we can see that the shared portion would actually suffice and would work the best to the advantage of claiming maintenance. So what we simply could do, we could hide that, and we could hide that top portion as well. And then we just work on the 2,400 Rand. Same goes for cleaning material. There we've used the exact same principle that you could do all throughout. As long as you can say, what is your calculation based on, and the reasons for that. And you can justify that. That would suffice. Same goes for domestic worker, garden services, insurance, same. Motor vehicles, the installments, exactly the same. Interesting with this, maybe I can just explain this a little bit more. If we were to use the simple acute principle on, say, for example, your total amount of fuel per month is 1,950 Rand. No, let's go to fuel, 1,400 Rand. If we use the acute principle, it would mean that the split would be 700 Rand for the mother and then 350 Rand for each child. But if we look at the actual figures, and I've actually done a simple calculation here, where it is said that, you know what, the total kilometers driven was 700 kilometers, and there was 1,400 Rand used for fuel. So it's very easy to work out, because you can do that on Google Maps, to work out what is the difference between the house and the first child, the 6-year-old's child's creche, and the 17-year-old school, and towards the mother, you know, with her workplace. See, that you can work out. Say, for example, you can work that out to say the mom drives 250 kilometers of the total 700 kilometers driven for the 6-year-old, 280 for the 17-year-old, and 170 only for herself. This is what it equates to in order to get the amount of 1,400 Rand fuel. It would mean that driving for the 6-year-old, the fuel expense for the 6-year-old is actually 504 Rand, because that works out to 36% percentage-wise, and the 17-year-old 40%, and then the mom only 24%. And then you can use these as actual figures of what is spent. Remember I said, you know what, it's not, I don't want a fixed amount of 1,000 Rand or 2,000 or whatever. Now we can actually work it out, and this looks on paper, and it is much more fair and reasonable, because then you can actually prove and justify that, you know what, for the 6-year-old, 504 Rand is spent in terms of fuel, 560 for the second child, for the 17-year-old, and then for mom, 504 Rand, or whatever the case might be. So this is what I meant by why it is advantageous, or to your advantage, to use a spreadsheet in order to allocate this, because that would mean that the amounts that you claim would be fair and reasonable. And there's also a way that you can indicate to the court that you gave it some thought, you gave it some consideration on how these amounts were arrived at. Obviously, there's some things that needs to be based on real figures. For example, school fees. Obviously, mom does not have anything to do with school, so those only gets allocated towards the children. Medical aid. Yes, if you do have a medical aid, the actual figures on the statement of the medical aid, where you can say this is the members portion, the main member, and these are the dependents. You include those real figures, and then you state there, you know what, under the comment section, it states how was it calculated. It is the actual figures, the actual values of the medical aid. Same goes, for example, for pocket money. And then you get to at the end, you get to the total column, which is obviously where you want to get at. Oops, here it goes. Sorry. So that is the amounts that you fill in on the J101 form. So that is basically the use of a spreadsheet in order to make it easier for the court to know how you came to those amounts. It works well in practice. We've seen that quite a lot. It is just so much easier. I take my laptop, I take to court. So if I'm there and I'm at a Section 6 or even a Section 10 inquiry, we can make alterations as we go. And that you can see on the subtotals how that would change and how that would reflect. So if you sit in a Section 6 inquiry, the informal inquiry, and the attorney says, well, yeah, they don't agree with this and they don't agree with that, and you come to some kind of agreement of the amounts that is needed, that could be changed immediately, and it could be redrafted, and you could see the whole picture unfold in front of you. And that is the advantage of having submitting a spreadsheet, additional spreadsheet in support of your maintenance application form. Right. Next one that we could look at is the submission of an affidavit. Now, yeah, the submission of affidavits sometimes it could be troublesome, it could be to your advantage, but it could also work against you. Remember now, if you submit an affidavit, then that would mean that you are stating something under oath. And that is not sometimes, that might not be to your advantage. So if you are not sure of your facts, then I would suggest that you do not submit an affidavit, because you could be held in contempt of court for perjury. You could be charged for perjury, and you don't want to go through that route. But it was always, some of the magistrates prefer that. They like that because it makes it much more complete, and it gives them the sense that you come to court prepared, and you know, and they would know because you submitted all the documents. So if we run through the affidavits, like I said, this is optional; it's not necessary, but it could also be, it could work, and it could fast track your application form. Why do I say that? Because the maintenance officer now, because they don't know you of a bar of soap, they rely on information that you put in the application form. So if your application form is not filled in correctly, then they have to get you in, they have to discuss that, and that takes time. And then you have to bring to court new documents, and that is another remand. And you don't want to postpone your case. You want your case finalized as soon as possible. So if we look at a simple affidavit, and this is an affidavit or standard affidavit that we sometimes use, and I'm just going to run through it quite fast because it's not difficult. The template will be available on the resource handout section of the link, so you can download this and you can use that. So you can simply just mark it in the magistrate court for the district of, and then obviously the district court or the magistrate court where you lodge your application. You can fill that in, or you can just leave it empty and the maintenance officer can fill that in. You write down your name and then the father's name, and then you simply say, right, some general information that you're an adult male or female residing at, and you put in your address. You can put in there. I will make this document available in Word format so that you could change it and you can type it in there, and then you can delete what is not necessary. So you can simply say that you are residing at a certain place and you're working there, and your identity document is annexed here to marked A, and proof of your home address is marked B. So what you do then is you make a copy of your ID document and you mark it on that little piece of copy. You mark A and your home address on B. And that you attach to this affidavit as well. You need to address Section 2 relationship. How are the people or are the parties interconnected? And then you can say, I was never married to the respondent, or I was married to him and I've subsequently divorced. You can change that. And you have the following child or children with him, and these are the names of the children. And then you attach marked Annexure C, all the birth certificates of the children. Right. Jurisdiction, that is just a normal one. Here you can delete that is not applicable to say, all right, I'm going to a court in the area where I live or where I work or carry on business, or where the children is normally residing. You can just draw a line through with the portion that is not applicable. Some background information. Since a certain date, you can say that the respondent has not supported the children, or alternatively, he has supported the children and he made so much contributions over that period. So you can give some more information there. You can state here you are currently unemployed, because the court might not know that. Remember, the court does not know you. They do not know you. So you have to present as much facts and information to the court for them to make a proper assessment. So there you can say that you're currently unemployed and you have unemployed since the date and the reason for your unemployment is, and then give a reason why you are not working. Just don't say, oh, right, I'm unemployed. You know what? Give a reason. You can state there, I have been looking for work, or I was retrenched, or I'm just finishing up my studies, or whatever. And these are the attempts that I've made to look for gainful employment, so that you can take the court into your trust and divulge that information. What you could also add there, if you are working, then you can just say, then you just delete this portion, and you can say, and you just use this portion at the bottom where it says that you're currently working at so-and-so, and you give the address and the name and the telephone numbers of the company that you work for, and you annex mark as Annex D, your salary slip. And here is the interesting one. This is what you actually want to submit to court, because the court needs to take cognizance of all the files and everything that is in the court file. So in all probability, the court will look at this, hopefully. Some magistrates don't, some do. But if they do, then this might fast track your application quite considerably. So here we take, as from that, like we saw on the spreadsheet, here you can say, this is going through the expenses of the children and justifying why you asked that. This would take away all the ammunition that could be used against you that you need to explain to court. If there is an attorney for the respondent, then they would have privy to this as well. They would have access to this, and then they would see what was your reasoning, why and how you calculated the expenses. Let's come to the amount. Let's just go through the first one. Now, these are all the same. You can simply copy and paste these as it runs through, as you mention it in your application form or your supplementary Excel spreadsheet. The amount that I pay, you state this under oath to say that the amount that I pay for the bond or rent is so much per month. I've indicated that said amount must be split as follows: so much towards myself and so much towards the 6-year-old or whatever the child, and so much to the other child. If you only have one child, you delete that portion. The calculation is based on the following, and there again, you delete which is not applicable. You can say, right, if you use the principle of a could versus a could, where it says 1/3, 2/3, you know what, the calculation of apportionment, allocating shares, or one share for an adult and 2 shares for an adult and 1 share for a child. If you use that one, then you delete the discretion section. Or if you use the discretionary system like we've done in the example of the fuel and the rent, then you delete a could versus a could one, or you can just simply blank that one out and then motivate it as follow. And there you can put in, for example, the rent. They use equally each and every room. The rooms are big enough for everyone, or mom uses 80% of the kitchen, or whatever the case might be. There you can put in your reasoning why you came to that calculation. Same goes for food, groceries, exactly the same. Household, electricity, fuel, school fees. Like I said, yeah, you can copy and paste these sections as many times as you wish. You can simply just copy that, and you just paste it there, and then you can say, all right, this is, for example, for it could be for Wi-Fi, and then you say, all right, you pay that amount for Wi-Fi. Each and every one could be justified, so that you justify each and every expense with regards to that. If we continue with the affidavit, the need for maintenance, it is submitted that there's definitely a need therefore. Obviously, the means of the respondent, you would not necessarily have the salary slip or the pay amount that the respondent pays. So what I usually do is, because that would be done during a Section 6 or a Section 10 inquiry. So I would say in the affidavit, I would leave it at that. I'm not privy to all the financial details of the respondent and can fully comment thereon. But if you do have copies of his payslip, then you could add that in there as well. You could just change that to say, I'm not privy to full financial details, but I do have a payslip. And then at the end, you just have the praise where you wish that the respondent be ordered to pay maintenance proportionate to his income based on his monthly or on the monthly expenses and the needs of the minor children, and that the maintenance officer, in terms of Section 6 of the Act, investigates the complaint and institute the necessary proceedings in the maintenance court. So this is just the form of a simple founding affidavit. This needs to be commissioned in front of the police. So you simply print this out and then don't sign it yet. You have to sign that in front of a police officer. And that is basically how the founding affidavit can work, and it could work to your advantage. And I would urge you guys to really consider doing this, because it really, really, really works. It takes a load off, and it shows that you have commitment towards your maintenance application form. Right, so in what order should all these documents be? Because we've got a whole book of documents that needs to be submitted, but it's actually very simple. You start off with a J101 form. Remember the form that you've completed, copy of your ID. If you have submitted your affidavit, if there's an affidavit, that would also be marked A, B, C, D, and E with all the annexures. You just include that as well. Copy of the ID, birth certificates of the children, the divorce decree, if it is applicable. And then obviously optional is you can print out the spreadsheet, which might be very nice, and also the founding affidavit, and then the proof of your income and your expenses. Those are all the documents that needs to be submitted to court. Right. So where do you hand the forms into? What do you do with the form? Now you've got this whole thing. Where do you go to? Right. First of all, each and every magistrate is considered to be a magistrate's court is also considered to be a maintenance court. So the area where you live, where you work or carry on business, or where the children live has got jurisdiction. So you can take it to any of those courts to submit your application form. So where do you hand the forms into? Please do not hand it in at the security in front, because they usually just chuck it away. Ask to speak to the maintenance clerk or the maintenance officer. You literally go there and you hand them a copy of this bundle of documents. So you give it personally to them. My suggestion would be to make at least 3 copies, or to at least 2 copies of all the documents. Always make copies of all the documents that you submit to court. The reason why I say this is that if you go to the court and now you hand in the documents at court, the whole submission of your application and all the supporting documentation, give it to the maintenance clerk. They need to put it on their system, or the maintenance officer, they needed to put it on their system and to process it and go further with that, and then ask them to stamp your copy as proof that you have submitted that. please do that in each and every time that you submit any document to court. Make 2 copies so that you have proof that it was submitted, because files do go missing. Files just simply disappear, and then they look for it, and that usually means a remand. So if you do have copies, and take that copies that they've stamped, take that to court each and every time that you go to court. Because if you get to court and they tell you, oh, the file is missing, then you can say, but I've got copies stamped by you of each and every time that I submitted the documents. So we can proceed, because here is a duplicate of that. And that is the reason why I feel very strongly about making copies and then having that ready on each and every subsequent court proceeding as well. How many copies do I need? I said 2. And then the follow-up procedure as well. Some of the maintenance officer would say, you know what, phone back in a week. We'll give you a date we'll get to the Regulation 3 directive out to the respondent to appear in court. We will address that in the next webinar and the one after that as well. But follow up, because if you do not follow up, they will definitely not call you. Most courts are not very keen on the follow-up procedure, which is vitally important for you then to make sure that your file actually progresses with regards to that. Very important as well, get the details of the responsible personnel. If you speak to a certain one, if you gave your documents to a certain person, they all have name tags. Ask them what are their names, what is their telephone number, what is their email address. Get all those details of each and every time that you have engagement at court and you have been held by someone. Get that detail, write that down, keep a diary of who you submitted documents to, because if something happens and the file goes missing, that you know where to find out. Where's the first port of call where you can find out where the file went missing. And then you can prove to the people, you know what, I've written the name down. I given it to this person on that day, on that time, and they stand for it. Here's my copy. So, you know what, go and look for the file at the end of the day. So keep the names and the addresses of those people ready as well. So that basically brings us to the end of this portion and all the groundwork that we've leading up to court and what will happen in court. And just to give you a brief summary, we're basically running out of time, but just a brief summary of what's going to happen next. Because remember now, we've been talking about how to get everything ready, how to work everything out, the expenses of the children, the you know, all those things we've worked out. So we're leading up towards what's going to happen once you submitted the documents at court, what will happen next. So obviously in point number 1, we've dealt with a complaint, the compilation of the documents, and then the submission to the documents to maintenance court. This is where we are now. Now, what would happen now? Obviously, the clerk of the court that will assist you, they will capture the information and they would hand that file over to the maintenance officer. So you could expect a call or a WhatsApp or a text message from the maintenance officer or the maintenance clerk to come to court on a further day, on a later day. Because in the process leading up to you and the respondent being together for a Section 6 inquiry, the maintenance officer will look at your file. They will investigate the matter as the Act says in terms of Section 6, and they would prepare for a Section 6 informal inquiry, which will be done in front of the maintenance officer in the office of the maintenance officer. So that would be in their office. It is not a formal process. It's an informal process, so it does not happen in court yet. It is just an informal one where they get the parties together and then they discuss your application form. This is also here where some of the attorneys might come in because he might be represented or you might have legal representation, and then the attorneys would talk to one another and just ask questions to either yourself or the respondent. So we're leading up to the Section 6 informal inquiry where both parties will be sitting in front of the maintenance officer in order to resolve the matter. And if the matter could not be resolved during this Section 6 maintenance inquiry, if the parties are in disagreement, then the maintenance officer could make a recommendation to court and then refer the matter to court in terms of Section 10. So in terms of Section 10, then the magistrate would hear the matter. He would do exactly the same as what has been done in the Section 6, but it would be in court. It would be much more formal. It will be a court proceedings where you will be sworn in, testimony will be led under oath, and you would also have the opportunity to cross-examine and be cross-examined on each and every item that you've listed on your J101 form. And that is the reason why I say that, you know what, take some time spending quality time and effort on completion and to the calculations and to how to work that out. Do not skimp on this. Do not use thumbs up figures. Do not inflate it to make it much more elaborate than it really is. At the end of the day, the court will establish, in terms of Section 15.3, an amount that is reasonable and fair for maintenance. So you will be cross-examined on this. And that's why I said that it might be to your advantage to submit an affidavit and a spreadsheet in order to give that information to court, because it's easier for them then to say, and they can say, but this is the amounts that you are claiming, and this is the reasons why you claim the amounts that you are doing. That is basically where we are in the process. On the next slide, yes, just coming back to this is the figure, this is a graphic that we've used previously, just to give you some awareness of where we are in the process. We're basically right in the middle now. We're working towards the informal, like I said, the informal investigation maintenance inquiry. So on our next Lunch and Learn webinar, is we will be discussing how to prepare for a Section 6 maintenance inquiry, of what it is exactly and what can you expect on the day of the inquiry. Also some practical tips on what could be done. Obviously how to fast track, because this is all about education and advising you how to fast track your maintenance application form. The role obviously of the maintenance officer will be discussed in maintenance investigator. We'll go into some details with that as well, and then also just give you a general overview on the whole process. So that basically brings us to the end of our Lunch and Learn session for today. My cup of coffee is ice cold already. I've been talking so much. There will not be time for any discussions today because we're running a little bit out of time, but you're most welcome. Give us some feedback if you enjoyed this, if you found it beneficial, if you do have some comments or some ideas on how we can make it better. Please drop us a line. We would love to hear from you. Send us an email on info@lunchandlearn.org.za. You can also contact my office if need be. My name is Eugene Opperman. I'm a family law practitioner. I've been practicing this family law for the past 23 years, and I enjoy every moment of it. I'm very passionate about child maintenance, also domestic violence, as well as children's rights. And that is the reason why I'm doing this and why I'm feeling passionate with regards to educating the people out there. So if you do have any feedback, any comments or whatever, we would love to hear from you. If you would love to become involved with some of these webinars, also maybe present one or two of those on a topic of your choosing, also most welcome. Drop us an email on info@lunchandlearn.org.za. Thank you so much for joining us today, and we will see you next week, same time, same place. Have a good afternoon further.